Hey, everybody. Welcome. You know what? I've missed you guys. It's been a crazy couple of weeks. I can't wait to fill you in on everything that's been going on. Um, so, buckle up, buttercups, because we got a lot to cover tonight and just a lot of stuff going on for me personally as well. So, and since you're all my pals, I like to fill you in on that stuff too. One thing I want to say to begin with, and I want to send a shout out and some prayer and some love to all of our folks who have been affected by Hurricane Helene. I'm worried about y'all. I've been seen some posts from Gigi from Pretty Lies and Alibis, and the eye wall of the hurricane came right over her house in Greenville, and so in South Carolina. And she and her family are okay. They didn't have any damage or not a lot of damage to their home. But if you remember when Gigi very first started out, she had a partner in crime who they called Fruit Loop, and had been her best friend from high school. And Fruit Loop decided to peel off from the podcast and began doing some really wonderful work with domestic violence women's shelter. But the shelter's up in the mountains, and they ended up having to hike out several miles to where Gigi could pick them up because there were so many downed trees and so much damage. Gigi said she still doesn't have power, but they have a generator, and so she has Fruit Loop and her partner and somewhere around 10 people living in her house right now, while they all wait for services to be restored. But there's so much damage and so many people still missing. And so please, if y'all can spare a few coins, donate. And if not, please just send prayers and good thoughts for all those folks. My daughter's best friend, who was a maid of honor in her wedding a year ago, is in Asheville, North Carolina, and they were heavily hit. Last I heard from her mom, she had not had water or power restored, but was making do. So just definitely keep those folks in your thoughts and your prayers, because people just need to pull together and take care of one another. And I just want you to think about those folks. Um, so wow, it's been kind of a wild 2 weeks for me. As you all know, I went to Las Vegas with my daughter, and there's nothing like going to Las Vegas. I went to see the Pink concert with my daughter, but my poor daughter, there's nothing like going to Las Vegas with your mother and your mother-in-law, because my son-in-law's mother was along as well, along with my son-in-law. So the four of us were in Las Vegas. We had a blast, spent 3 days down there. And then I flew back to California for a few days with my daughter's son-in-law and his family. And unfortunately, got a real ugly, I think a little bit of, I'm not sure whether it was stomach flu or food poisoning, but I sort of leaned toward food poisoning, and ended up having to spend an extra day down there and postpone my flight to come back. So, but I'm feeling better. Last week, I was in Portland, or on my way to Portland to Powell's Books. I also did an appearance on the big ABC affiliate in Portland, Oregon, KATU TV, for their morning show called AM Northwest and their afternoon show. The clips are in our show notes if you want to see that. It was really fun. I hadn't done any TV interviews in a while, so that was kind of fun. And then I went to Powell's for a book signing. I was having a little trouble getting the PDF up, so when I get that picture available, I'll share it. It's shared all over social media, so if you follow me on any of the socials, you've already seen it. So, but probably the most exciting thing going on that happened this week is this. The book was excerpted in People Magazine's digital edition. So if you are a People Magazine follower, you saw that on their digital edition. I want to thank Dawn, who posted a lovely comment there on the People Magazine site about the book. So thank you so much for that, Dawn. One thing I have a book signing coming up. I'm driving to Ashland, Oregon tomorrow. That's about 3 hours from where I am, down in southwestern Oregon, for a book signing there. And then I will be in Bend, Oregon on the 10th for a book signing. And I'm excited about that one because it includes my friends and neighbors from Bend, as well as the folks that I went through my master's program, my creative writing program with. So I'm excited about seeing old friends. My mom wants to go to that one, so she's excited that she's going to get a chance to go to. So all of my book signings are in our show notes. So I do have a couple things that we're working on. I've been working on trying to get to Boise because there's a lot of interest about the book because of the Boise connection, and wasn't able to get that scheduled in November. Weather's going to get bad. People are going to get involved with the holidays. So I'm hoping I am going to be in McCall, Idaho on the 2nd of November, but then I'll be going to Boise, I'm hoping in May. I also am going to be in the greater Phoenix area during the week of Valentine's Day, so the 13th through the 18th. All this information's in our show notes, so you don't have to write anything down or memorize anything. But keep in mind, we are, my publicist at the publisher is working on setting up a book signing in the Phoenix area while I'm there. So that's exciting because we know this case started in Phoenix, and I'd love to see all the folks who got interested in the case because of the Phoenix connection. So look for those coming up. I want to say thank you for everyone who so far has posted a review on Amazon. I know that there are other sites, Goodreads and several other places where I appreciate that people are posting reviews. Reviews are so important to authors. Pre-sales and reviews are the two things that are just critical for us. And reviews in particular, reviews on Amazon. Here's the thing with Amazon. If we get 60 reviews, then Amazon will put the book into its algorithm, its rotation, and begin recommending it to people who have ordered other true crime titles. So it's really important that you that we get those reviews. And as of today, we had 31. So I need 29 more reviews. Now, 100 of you out there got the book and agreed to review it in return for getting the early manuscript. So I'm hoping that those of you who haven't yet posted your reviews will do that. If you got a copy of the book once it was released, please, once you're finished, I know people are still in the middle of reading, please consider posting a review. The Amazon reviews probably help us the most. The other thing I wanted to say is that the book is available both on Audible and on Kindle in a digital version. I've had lots of great feedback and really a lot of good response to the narrator that we picked. The narrator was someone who our publisher presented to me. They presented several different options. And my daughter and I, while we were at CrimeCon, listened to the different ones. And this was the narrator we liked best. So I'm excited that everybody else is finding her narration easy to listen to, a good cadence, all of those things. So please let me know if you would like a signed book plate for your book. I am sending those out along with stickers and swag to anybody who posts a review and then sends me their address. But if you would like to have a signed book plate to go in your book, let me know. Just drop us an email. Our email is in the show notes. And let me know. And I will be most happy to sign a book plate and send it off to you. Well, we have a lot to talk about tonight. So let's get into what's been going on the last couple of weeks in true crime. First of all, I want to talk a little bit about what's coming up in October on the trial schedule. On the 2nd of October, we have Brian Walsh motions. These, I think, are going to be interesting because they deal with, once again, Michael Proctor. There are 3 high visibility cases right now that deal with Michael Proctor, who was the Massachusetts state trooper who was in charge of the investigations of Karen Reed, Sarah Birchmore, and also this Brian Walsh case. So it'll be really interesting to see how they're going to handle the issue of Michael Proctor, who is currently on unpaid leave while he's being investigated by the state police. Those of you who followed the Karen Reed case know that he is just simply a really ugly, bad cop. And there's some suggestion from the Reed case that he also was, may have manipulated, let's say, evidence. So that one is coming up on October 2nd. Then on the 7th, of course, we have the Boone trial. And we're going to talk much more about Sarah Boone tonight. The 15th through the 31st, we have Richard Allen's case in the Delphi murders. And then on the 22nd of October, we have Ashley Benefield being sentenced. So we have some things to talk about tonight about those upcoming cases. So, but I do want to kind of just quickly talk a little bit about Puff Daddy, or P. Diddy, as lots of folks call him. I loved Jen's post in our group chat tonight, which was a little note that said, we're talking about doo-wah, diddy, diddy, Donna A. and Boone. So I'm sure you can hear that little music in your head. Doo-wah, diddy, diddy. Anyway, you don't want me to sing. Anyway, so we're going to talk a little bit about Diddy. So as you know, he was arrested and is being held in custody on charges of human trafficking, of a lot of, I really think they're trying to make a RICO case, sort of lining this up with Young Thug and YSL, these sort of rapper criminal enterprises. So it'll be interesting to see how that comes together. But he's being held in custody. But today, now, let me just back up a little bit, because y'all may not know that this all really came to light when his former girlfriend, she was his longtime girlfriend, Cassie Ventura, filed a civil suit against him. Now, the civil suit was settled, I believe, but all of this information came out about Diddy, about his freak offs, as he called these wild parties, and all of the mistreatment of people, the essay, all of those things. So, I honestly don't know why I tippy toe around it, because being monetized here isn't really a priority for me. So if YouTube demonetizes, oh well. There's all kinds of allegations of human trafficking, of sex trafficking, of forced sex abuse, a lot of other things. So, um, but what has been really interesting and what happened today was the lawyer who has been representing Casa Ventura has been inundated with other people who indicate that they were also Diddy's victims. So they have now filed suit on behalf of 120 potential victims, the youngest of whom is a 9-year-old male, was a 9-year-old male at the time of the incident. So there's way more coming down the pike, so to speak, for Diddy. So he gave a bit of a press conference today, and I thought it was interesting. He said they'd had over 3,200 claims of people who'd contacted them to say that they were victims of Diddy. But you never know how many of those people are the real deal, or people who are just seeking fame, or people who are not entirely mentally there. And so you have to really sort out what of those claims are actually valid. But it is interesting that they have been able to substantiate 120 claims already of those 3,000 reports. So I think we're going to see a lot more of P. Diddy, both in civil cases and in criminal cases. And they say the conduct spans over 20 years, and they are intent on going after the enablers and the accomplices. So I don't think Diddy is the only one that we're going to see that's going to be held responsible. And I think, stay tuned, because there's a lot more to see in that case. I do want to talk a little bit about Donna Adelson. Now, as you all know, her trial that was supposed to start last week or the week before was postponed because of an issue with a conflict with the lawyers. And I know it's been all over YouTube, and so I won't go deeply into it. Attorney conflicts, some can be waived and some can't. And the waiverability depends on both of the parties who are being asked to waive the conflict. So it wasn't enough for Donna Adelson to say, yes, I know there's a conflict because Dan Rashbaum previously represented my son. Charlie Adelson also had to say, I'm waiving any conflict that I might have based on, because Rashbaum is going to represent my mother. So the problem was, there were two problems. One, Dan Rashbaum didn't get Charlie's waiver in writing. That's not as critical because Charlie could withdraw his waiver at any time. Waivers are ambulatory. Waivers are living, breathing things that can be withdrawn at any point. So Charlie, after he consulted with his appellate attorney, decided that it probably was ill-advised for him to waive the conflict with Dan Rashbaum. And what that led to was, at the very last minute, um, one of the things that happened was Charlie was in North Dakota in a jail in a prison in North Dakota. He'd been moved because of all of um, his throwing the Latin Kings under the bus, and how many of those guys were in prison in Florida in the Department of Corrections in Florida. And so he was moved for his own protection to North Carolina. So that meant that he was less accessible to his lawyers, including to Dan Rushbaum. So it wasn't until he was brought back to Tallahassee to appear as a witness in Donna's case that Rushbaum then sent somebody out to try and get that waiver signed. And when they got there, Charlie said, "No, I'm not going to sign that waiver, and I'm withdrawing my waiver based on the advice of my appellate attorney." So then they were stuck because Dan Rushbaum had been lead attorney going up to Donna's trial. So the judge reluctantly and wasn't so happy about it, but reluctantly agreed to a continuance to allow the second chair attorney to get up to speed and be able to finish and defend the case. So I don't believe a new date has been set yet, but it would surprise me if it goes much farther than into February or January or February of next year. So that is the Adelson case. I think we're going to continue to see that moving forward. I think everyone wants it to move forward quickly. She has not waived her speedy trial rights, as far as I know, and the prosecution certainly wants to get the case tried. So I want to talk about a couple of other cases before I launch into Sarah Boone. The Young Thug trial is still going on. It's been going on for months and months and months. There's a new judge. Judge Glanville was disqualified, and this new judge is a woman judge, fairly no nonsense, but she has repeatedly rebuked the prosecution for their poor work, and in some instances, their out and out deception. The most recent was had to do with the fact that they were asking questions in a way that was confusing and suggested by asking this defendant, "What did they say or they tell you?" suggested that it was one of the other co-defendants when it wasn't. But you begin to wonder, is this judge ever going to have enough and just say, "We're having a mistrial"? The prosecution has been so blatantly dishonest and has so blatantly bent the rules that it does make you wonder if there is ever going to be an instance where a judge is going to say enough is enough and declare a mistrial. So there is a really interesting case that has popped up just recently out of Kentucky, and it is Sheriff Nikki Steins. This is a case where the sheriff in a small town where everyone knows everyone and everyone involved in law enforcement talks to one another all the time, walked into a judge's chambers for a private conference and shot and killed the judge. There was a probable cause hearing this week, and unlike a lot of states, Kentucky apparently has a probable cause hearing for the purpose of determining whether there's probable cause to hold the defendant while a grand jury is convened, because it's been referred to a grand jury. But there was surveillance video in the judge's chambers, and it caught everything on video. There was no sound associated, but there was video. Now, what what came out at the hearing was that the sheriff apparently had questions about why the judge was communicating with his teenage daughter, um, and whether why the daughter's telephone number and messages were on the judge's phone. Much more to be disclosed there. The sheriff came out during the probable cause hearing that the sheriff said, "They're trying to kidnap my wife and child." So nobody really knows what this case is all about. It's pretty interesting, and it's certainly not something you see every day in a small community. It would have been like somebody doing something similar in Fremont County in Idaho. It's a very small rural town, where everybody knows everybody and everybody knows the sheriff and the judge, and so um, more will be revealed. Alec Murdoch got word that his appeal on the federal fraud and theft charges was dismissed. The appellate court found that as a function of his guilty plea, he waived his right to appeal. And that is very typical in cases where there is a plea. Very typical for the judge to say, do you understand that as part of this plea, you are giving up most, if not all, of your appellate rights? So it would have been in the plea petition. It sort of, the appellate court basically said, nice try. So Alec Murdoch will not be able to bring an appeal on the federal charges. We still are awaiting his appeals on the murder charges, the state murder charges. He likely, since he pled guilty to the state fraud charges, will run into the same problem appealing the state fraud charges. So Delphi is coming up. Richard Allen is being tried for the murder of two 14-year-old girls. His defense attorneys have alleged that it was not Richard Allen who committed the crime, that it was, in fact, a Norse religious cult called Odinists. And they did seem to have some relevant evidence that might have pointed that direction. The judge in this case, this is the same judge who dismissed both lawyers as unethical and incompetent, and they had to go all the way to the Supreme Court to be reinstated. She is very clearly biased against the defense, and she, of course, denied all of their motions to present third-party culpability evidence. And she also ruled that Richard Allen's confessions will come in, even though his attorneys argued that the confessions were coerced by the prison staff who are Odinists. So she apparently didn't buy that argument and declined to allow that information to come in. Karen Reed, the defense, has filed their opening brief in the appeal on the partial verdict in their case. It's a really novel idea. I mean, it's a very novel issue. It is what the law calls an issue of first impression, meaning that there isn't case law, either federal or state case law out there. We had a similar issue with Vallow Daybell, and that had to do with whether or not the court had the authority to dismiss the death penalty. Now, in that case, there wasn't any state appellate decisions, but there were a couple of other decisions, both in federal court as well as in different states, that could be used as a guideline. So the way it works is, if you are citing precedent, in order for that precedent to be controlling, it has to come from your jurisdiction or from the federal government if it is a federal issue. So typically, lawyers are going to be looking for state precedent that supports their position. In that case, there was no state precedent, and so they were forced to use other states and federal government precedent. Likewise, that is the issue in the Reed case. There is no Massachusetts law that says what happens if post-trial you find out that the jury has actually decided 2 of the 3 counts and is only deadlocked on 1 of them. So they have filed their opening brief. The prosecution, the defense is saying that Karen Reed was entitled to an open and public verdict, and that in addition, the fact that a jury had been seated, heard all the facts, reached a verdict, activates double jeopardy. So the big question for the appeals judges is going to be, in that specific instance, when did double jeopardy attach? And is the state precluded from bringing those charges again because double jeopardy precludes it? So it's, from a legal wonk standpoint, that's an interesting argument and an interesting legal issue, and learning how the Massachusetts court is going to reason that. It's interesting to us legal wonks. Now, I delayed talking about 2 cases and kind of leaving them for last. One is Sarah Boone, and the other is Alexis Treviso. I did that because both of them have issues that raise whether or not a defendant's statements should be suppressed because of Miranda. So I want to talk a little bit first about Alexis Treviso. Now, you may recall Alexis Treviso was a 19-year-old high school student who was pregnant. She claims that she didn't know she was pregnant, although other people say they think she did know. But she went to the hospital with what she claimed was a terrible backache. While she was in the hospital, she suddenly said, "I have to go to the bathroom," rushed down the hall to the bathroom, and was in the bathroom for an extended period of time. When she came out, a nurse went in, there was blood all over, and they found a deceased infant in the garbage. Alexis' reaction when she and her mother were in her hospital room and were told about this, her reaction and the things that she said were caught on videotape. So the defense claimed, filed motions to suppress, claiming that none of those statements did not receive her Miranda warnings and wasn't advised of her Miranda rights prior to making those statements. The other thing they said was that any statements that she made to medical personnel were protected by HIPAA, by the healthcare privacy rules. So I wanted to start out, first of all, and talk about, I don't want to delve too deeply into HIPAA because the appellate court really, or the judge didn't really get deeply into it. Because what the judge said was that there was a doctor-patient privilege between Alexi and her medical providers, and that should have protected anything she told them. And she wasn't Mirandized before she made any of those statements. So I want to talk first of all about Miranda. The judge did say that the decision turned more on Miranda than on the issue of the doctor-patient privilege. So what happened was that she was videotaped, her reaction to them saying we found an infant in the trash can. So Miranda has some very specific rules. So it comes out of a case, Miranda versus Arizona, I believe, and the case stands for the prospect that before law enforcement can question a person who is being detained or is in custody, they must first advise that person of their Miranda rights. They have to advise them. You have a right to remain silent. You have a right to have an attorney at all stages of your questioning or all proceedings. And you have an absolute right to remain silent and to have an attorney with you whenever you're questioned. There are a lot of cases over the years that have interpreted the Miranda rights. And when the biggest question when we're asking about Miranda is whether or not the person was in custody, whether or not it was a custodial interview. Now, it might seem like that's a no-brainer, but it really isn't, because think about this. Alexis Treviso is in a hospital bed. She's just given birth. Her care providers are telling law enforcement, we're not sure whether she's completely delivered the placenta, she's still bleeding, we need to have her airlifted to a different hospital, and we are concerned that she is not medically stable. So she's in a hospital bed. Is she being held custodially? Could she? I mean, the question is always when you're asking in Miranda, is this a custodial interview? Is that person free to leave? Well, it's kind of hazy. Was she free to leave? I guess, but it would have been against medical advice. And was she in any shape to leave? No, she wasn't really in any physical condition to leave. So that is the first question. Should they have advised her of her Miranda rights before police began to talk to her? And the court found, yes, that police should have advised her of her Miranda rights before they started to question her about the baby in the trash can. The judge also said that the spontaneous things that she said when they told her they had found the baby's body were protected as privileged between a medical provider and a patient. So the prosecution has already filed appeals as to these issues. They believe that it was not a custodial interview and therefore Miranda was not necessary. So that is going to have to be something that the appellate court is going to have to decide, and really is going to turn on those specific facts. Her in a hospital bed, lots of medical people, her medically not stable, all of those things. So was she really free to leave? And the other thing that the prosecution is saying at this point is, because her mother was present in the room and she's an adult at 19, she's not a minor, and her mother was in the room, generally, if there is a third party in the room while you are talking to someone with whom you have legal privilege, the presence of a third party invalidates legal or waives the privilege. So the state is going to argue mom was in the room, that invalidates or acts as a waiver of her privilege to have private conversations with her medical providers. Now, this would be different if she'd been a minor and mom had been in the room, but she was 19, so she was legally an adult. So at this point, the prosecution has dismissed the charges against Alexis Treviso because the trial court judge said none of that information, none of the utterances, the reactions that she had to the news that they'd found the baby's body, and none of the just conversations she had in the room between the medical providers and her mother, or the conversations that she had with law enforcement can be brought in. And that is, I mean, there is no case without that. So the prosecutors have sort of dropped back and punted. So they are at this point appealing the trial court's ruling, suppressing all of those statements. And if they get a favorable ruling from the appeals court, they will refile the charges. But right now, there are no charges. So, and that brings us to Sarah Boone, because that is also, there is also was also a motion hearing today about a challenge to Miranda for Sarah Boone. So let me get out of the way this sort of silly stuff first. Sarah Boone filed a motion asking the court to order that she could get a professional haircut, and also that she could use makeup in the courtroom or before court, and that she was that she not be shackled in the courtroom. So the judge said her hands will be free. She will be brought back and forth to counsel table the same way Lori Daybell was in her leg restraints. And that will be done outside the presence of the jury, because the issue is, if a jury knows that someone is currently in custody, it has the probably unconscious effect of saying, since that person's been arrested, they must be guilty. So in general, when we are seeing someone in front of a jury, they appear in civilian clothes and in restraints that can't be seen by the jury. So the judge said Sarah Boone will not have her hands restrained. She will not be in belly chains or in handcuffs, but she will be in leg restraints. She will be brought in and out of the courtroom outside of the view of the jury, so that they won't see that or hear that she's walking in leg shackles. The issue is, if she's going to testify, which her attorney has said she will, if Sarah is going to testify, how do they navigate her getting from counsel table to the witness stand without the jury being aware that she is restrained. So that was an ongoing conversation that they were going to have with court security. There are restraint mechanisms that go on the leg that are not chains. There are stun, and in fact, the court originally ordered her to wear a calf. Uh, when she was representing herself, the judge ordered that she wear a calf taser, basically a device that goes on the calf, and that if a person were to attempt to flee or get out of line, they could push a button and she would be tased. Usually that's enough to disincentivize someone from misbehaving in the courtroom. And I don't really expect that Sarah Boone will misbehave in the courtroom. I mean, I think it's a mistake that she's going to testify, but that has more to do with how the jury is going to perceive her. Doesn't have a lot to do with whether or not I think she's a threat to anybody in the courtroom except herself. I think she's going to shoot herself in the foot testifying. So the judge initially ordered that the sheriff would facilitate getting her sizes and her measurements, that her defense attorney would be in charge of making sure she had clothing for trial, and that following that, they would bring the clothing, the sheriffs would bring the clothing to the courthouse. She would be dressed for court at the courthouse in one of the holding cells, and then she would be brought into court. The judge initially said, I'm not going to let anyone back into holding cells, but I will allow the defense staff, if there's someone on the defense staff that wants to apply some makeup in the courtroom, I will allow that, but I won't delay court in order to get that done. So if somebody can quickly brush on some makeup, fine. Otherwise, it's not going to happen. Then the deputy walked up and talked to the judge, and the judge said, wait a minute, the deputy is saying to me that allowing someone to put makeup on in court then introduces potential contraband back into the jail. I know it seems like a petty thing, and in a way it is, but we don't have any way of knowing what that makeup contains. And there are many things, LSD for one, that can easily be mixed into makeup or stickers or those sorts of things. So the judge then backtracked and said, that can't happen. So Sarah is going to have to go to court without a professional haircut and without makeup. That is a consequence of being held in custody pending your trial. So there was also another quick motion that was brought having to do with a protective order that the state was asking for. As I understand it, Sarah Boone's lawyer was attempting to bring in information that indicates that both Sarah and George, the victim, had previously been accused of domestic violence, and that there had been instances where where Sarah had communicated to the prosecution that she did not want charges to go forward. The defense attorney was trying to get someone from the prosecution to come in and say, it's not her decision. We take that into consideration, but the decision ultimately rests with the prosecution. The prosecution came in and said, oh, no, you don't get to do that, because determining whether or not a prosecution goes forward is covered by attorney work product privilege, and the judge agreed. So there also were a couple of other things that came up that I thought were worth mentioning. The last one is that they were deposing expert witnesses as recently as this morning. An expert who met with Sarah Boone was supposed to be deposed on her findings, and then the defense was supposed to also be able to depose the prosecution's expert. The prosecution said to the judge, based on those conversations, those depositions, we anticipate that we're going to be filing a motion in limine to exclude the battered spouse defense. Now, they have filed notice that the defense has filed notice that they intend to invoke the battered spouse defense. It's a bit of a problem for Sarah because that is a form of self-defense. So what that means is I committed the crime, but I was defending myself when I did it. That is a vastly different argument from it was an accident, which is what Sarah Boone said initially in her interrogations with the police, in her interviews with the police. So I'm expecting that instead of jury selection on Monday, we may very well get a hearing on that motion in limine before jury selection starts. Now they're going to bring the jury in. The judge said tomorrow is a court holiday. I'm not sure which, maybe it's Columbus Day, I don't know. But they are, he said he will be working. He was going to be issuing written decisions on the motions he heard today, and he would be considering anything that came in as quickly as he could. But I do think there will have to be a hearing on the motion in limine, and that motion could require testimony from a couple of different expert witnesses, so it wouldn't necessarily be a short hearing. The judge did say on Monday that they would at least get through the cause challenges, so the challenges to people who have already formed an opinion, have knowledge through the media of Sarah Boone's, what she's been accused of, and have enough knowledge through, oh, it's Rosh Hashanah. I'm sorry, I should have known that. Thank you, Jennifer. Not every state has a court holiday, but there is a very large Jewish population in Florida, and so I could see where the state of Florida would have a court holiday on Rosh Hashanah. So the judge said he wanted to at least get through some of the for cause kinds of challenges to the jury, dealing with people who had already formed an opinion about the case. But the biggest issue was Miranda. Once again, whether or not she had appropriately been read her Miranda rights prior to a custodial interrogation. So the defense filed a motion to suppress, and the motion to suppress is based on the fact that Sarah was read her Miranda rights twice. Once while she was in the back or in a police car, and once while she was actually in an interview room at the police department. The state agreed and stipulated to the fact that during the interview at the police department, she was in custody. She was not free to leave, And the police had the intention of arresting her regardless of what the outcome was of her custodial interrogation. So the sequence of events was the incident happened on the 24th. That afternoon, the lead detective had Sarah come and sit in her car. The interrogation was captured by on video. I don't know if it was body worn or whether it was within the car, but it was captured. And during that conversation, the officer read her Miranda rights, even though they told her she was free to leave after their conversation. They also obtained a waiver for her phone, to search her phone. So once the police officer had seen the videos that were on her phone of George in the suitcase and begging to get out and her taunting him, they had a conversation in the car. They didn't delve deeply into and didn't tell Sarah that they had seen those videos, didn't delve deeply into it. And it wasn't until the following day, Sarah called and said, "When can I get my phone back?" And they said, "Well, you can come down to the station and pick up your phone." And the lead detective said, "I'm pregnant. I don't feel very well. I'd appreciate it if you could come down and get the phone. We're not going to bring it to you." That was a ruse because they wanted her downtown, because they wanted to arrest her, because that morning, that officer, that detective had attended the autopsy and was aware of the autopsy findings, including the fact that there was blunt force trauma to George in addition to the suffocation injuries. So they sat down with Sarah. The detective promptly launched into, I have autopsy results we need to talk about, and we need to talk about them. They brought her in under false pretenses, which is not illegal. And but in both cases, when the police officer read her Miranda rights, she omitted the final question. Apparently, there was an updated version of the Miranda card, and the updated version included a question: do you understand your rights? And considering those rights, are you still willing to speak to me? The judge pointed out in the Miranda hearing today that there is nothing in any of the case law that requires that question be asked. Once again, the case law says the person has to be advised of their absolute right to remain silent, and they have to be advised of their right to have an attorney present during their questioning, and they have to be advised that if they decide to speak to the police, anything they say can and will be used against them. So those are the things that they have to be advised. You have the right to remain silent. If you choose to waive that right, anything you say can be used against you. And you have the right to have an attorney present at every phase of the proceedings, including during your questioning. But there is no case law that says you have to ask whether or not that person understood and, in light of those admonitions, is still willing to speak to them. Now, it is frequently and typically asked, and it was within the procedures of the police that they use the current Miranda card that asks that question. So the attorney argued that it wasn't enough to just say the case law only requires this, that you had to look at it in the totality of the circumstances, which is a legal test that is often invoked in cases. So, looking at all of the circumstances, did Sarah Boone believe that she was not free to leave and that she had a right not to speak about the case? Um, Based on the trial court judge's questions, I don't believe this is a winner for Sarah. I think all of that comes in. But I think that the attorney was doing a good job of setting it up as an appellate issue. I don't particularly think that it has legs as an appellate issue either, but I do think that the attorney was doing his job. He was making his record and setting up any potential issues, even if it is just let's throw it at the wall and see what sticks. His obligation is to preserve every possible issue on appeal. So I think that he was doing that. Once again, the question was the interrogation custodial or not? In this case, it was clear that it was custodial, and the state stipulated, yes, she was in custody. The law enforcement lured her down to the police office with the intent of arresting her. The probable cause was based on on what they had seen on her phone and the results of the autopsy. And so I don't believe, based on the judge's questions, that the judge is going to find that final taking all those that final question of taking all your rights into consideration, are you still willing to talk to me? Question. I don't believe the judge is going to find that question was necessary, or that Sarah Boone felt coerced into giving an interrogation despite the warnings. So why is this important? Why is her attorney trying so hard to keep her statements out? Well, because she's made conflicting statements. She's made conflicting statements. During her custodial interview, she claimed that George being zipped into a suitcase was an accident. And she claimed that they were playing around, they were playing some sort of game of hide and go seek, although we all know that's not how hide and go seek works, and that she zipped him in the suitcase, that they were horsing around. She then, because she was drunk, went upstairs and passed out and didn't realize until she woke up in the morning that George had not been able to free himself from the suitcase. She is now claiming that they were messing around. She zipped him in the suitcase, and then she was afraid of what he would do if he were released from the suitcase, and so didn't let him out. That is a very different defense. So she's got two different stories, and the prosecution is going to hammer her on those inconsistent stories. They are definitely going to be able to say, but in your interrogation, didn't you say this was an accident? And didn't you actually taunt him and zip him into the suitcase and leave him there on purpose? So it's giving the state a lot of fodder. And I feel for this attorney, he's taken this he's taken this case essentially pro bono. He has said, you know, it is possible that I will get paid if Sarah ever is able to pay me. But that's highly unlikely. So I think that if the judge does, as I expect, doesn't suppress those statements, then I think all of that information comes in, and then the prosecution it's fair game for the prosecution to say, well, back when it was all very fresh in your mind, you told police that it was all a game and it was an accident. and that you were heavily intoxicated and you forgot him in the suitcase and it was an accident. Now you're saying that you were afraid to let him out of the suitcase and you are claiming this battered women defense. Which is it? Were you lying then or are you lying now? And that is very fertile ground for pointing out that someone has changed their story, and very fertile ground for the prosecution to point out the one of the many weaknesses in her case. The other thing that happened today, though, was that Sarah Boone testified in the Miranda hearing. She got on the stand and testified about her state of mind at the time that she went to the police department and at the time that her Miranda warnings were read. I think this may have been a mistake on the part of the defense, although if we know anything about Sarah, it is that she wants to tell her story. And she has an absolute right at every stage to testify. So it may have been an instance of her lawyer saying, this is a bad idea, but you have a right to do it anyway. So it is, she decided that she was going to testify. And she did so. I don't think I think her lawyer was cautious in trying to keep her from opening up a door or opening up a can of worms that couldn't later be closed. I think he managed to keep her on track. So I don't know that she did a lot of damage to her case at this point, but there's no question she's going to testify. Her attorney has already said she will be testifying. So that's kind of the wrap ups. It was kind of interesting to have a couple of cases that had Miranda issues. And in one, we saw the defense prevail and get statements, their client's statements suppressed, and now waiting on an appellate decision. And in one case, I think we are going to see the judge decline to suppress Sarah Boone's statements. I don't think that the case law or federal Miranda law supports a finding that a question, a direct question is required before Miranda attaches. So before Miranda's effective. So I don't think that they're going to be able to say she didn't know that she could remain silent, or she didn't know that she could she had a right to have an attorney presence because you didn't ask her if she understood. They did ask her if she understood her Miranda rights, and she said yes. They didn't ask the follow-on question of, considering those Miranda rights, are you still willing to talk to me? That's the question that the defense is claiming invalidates the Miranda warnings. I don't think it does, and I think we're going to see the judge make a very quick ruling on that. We are still going to probably have a hearing very soon on the motions in limine. Don't know when that's going to be, whether it could be on Friday or Monday. I think it's likely that it'll be on Monday, and they'll do some jury selection, hear the motions in limine, and then go forward. I do not, we have not heard all of the arguments having to do with the defense and the state's motion in limine. I don't think that the judge is going to grant that motion in limine and preclude her from using the battered spouse defense, because I think the judge is going to say that is a factual issue, which is up to the jury as the trier fact to decide whether they believe that or not, whether or not there is an affirmative defense. is very much a jury question, and I think a judge is going to, the judge in this case is likely to say, I'm not going to remove that from the purview of the jury. That's soundly a jury question. So now that I've been through all of those things, oh, I did want to say, before we start to take questions, you can go ahead and post your questions if you haven't already. Jen will be starring them. And while she's doing that, I wanted to mention that there has been some action on the Daybell property. Now, I'm not involved in this project in any way other than to say that I think the folks who are doing the project have really, their hearts are in the right place. They recently, a week ago, last Friday, demolished all of the structures, the house, the barn, everything is gone, including JJ's tree. The tree that is so prominent on my book cover. They asked the family members as well as law enforcement about how they felt about the tree, and they unanimously and to a person said, we want the tree gone. So the house came down, the chicken coop came down, the barn came down. There are no longer any structures remaining on the property. They are working to secure the property to keep trespassers off. They will continue their plans. Now, remember, it is getting to be fall in Rexburg, and fall comes very quick, winter comes very quickly to the Great Basin and the high desert, Idaho, high desert in Oregon. What usually happens is we have a beautiful fall weather, Indian summer weather, where we have frosty nights and lovely sunny days until about late October. And then the powers that be flip the switch and it gets cold and we get snow flurries and the kids go trick-or-treating in their woolies, and I'm certain that that is what they're anticipating in the Rexburg, Fremont County area as well. So that being said, I think we will see they're battening it down, prepping it for winter, making sure there aren't going to be any frozen pipes or water leaks and gas leaks, those sort of things, getting everything secured for the winter. And then I think they will take some time to do a little more planning on what the next phase of the project is going to look like. They were really blessed to have construction companies in the area donate their time to voluntarily demolish the property and to remove all of those symbols of the tragedies that happened on the property. And now the way is being cleared to do something positive with it. So that was good news. And I think with that, we're ready to take questions. Yes. Oh, Kohberger updates. Thank you, Jen. I skipped over that as I was skipping around in my notes. So let me get back to Kohberger. As we discovered in the Vallow Daybell case, when a judge grants a change of venue, that judge can say, I want to go with the case when it moves, and we saw Judge Boyce do that. Or the judge can say, I want to be replaced with a judge from the jurisdiction where the trial is going to be held. In this case, Boise. So the Chief Justice of the Supreme Court came down and said that, sorry, had to turn my ding dong off on my phone. The Chief Justice of the Idaho Supreme Court came down and said the case is going to move. It's going to go to Ada County in Boise. And Judge did not ask to be to continue with the case. In fact, he asked for a new judge to be appointed. And so I'm appointing an Ada County judge. I want to say that judge's name is Hitler. No, Hiller. Hiller? Somebody will tell me in a minute. The judge had an initial hearing. Everybody was there, and he said, "I'd like to say I'm happy to be here, but I'm not going to start this trial with a mistruth." It's clear that this judge is very no nonsense, is going to get this case done as straightforwardly as possible, but is not thrilled with the idea of being on this really high profile case. He's taking the case because it was assigned to him. He was very clear with the parties that he was going to set a motion schedule, and he was going to brook no nonsense when it came to personality conflicts between prosecution and defense. Now, I will say that I think that they have done a pretty good job of keeping that to a minimum. I think Ann Taylor is a consummate professional, and I don't think that Hippler, there you go, thank you, Rose Kay, Judge Hippler. I knew it wasn't Hitler, but I knew it was close. So I think this judge has made it very clear that he is going to move this case along, and that he's going to take a firm hand with it. However, Ann Taylor, when they talked about a trial date, Ann Taylor made the court aware of a couple of things that have been problematic. A, she just received a whole nother dump of discovery. Now, it's very possible, like 300 terabytes, I mean, it's a lot. It's very possible that information could be duplicative, but they're not going to know until they go through it. And that is a big process. Additionally, they let the court know some time ago that one of their experts that they had relied heavily on in their mitigation phase had died. And unfortunately, they were having to replace that person, and that person was having to start from square one again. So she was also clear about what she expected the time frames to be. So the judge looked at that and said, you want to start a trial, the prosecution wants to start a trial no later than June. Initially, they had planned that so that both the high school that is next door to the courthouse in Moscow and the university would be out of class, and there would be less congestion and traffic in town around the courthouse. Now that the case has been moved to Ada County, that's not really a consideration. But what is a consideration is whether or not they're going to be able to seat a jury if they tell the jury, we're going to take up your entire summer and your entire opportunity for summer vacation with a trial. And so the judge expressed some concern about that. And I think it is very likely that we're going to see that trial start in October and not in June. I think it's very likely that the judge is going to say, I do not want to seat a jury that is going to have to spend their entire summer, so nobody gets a summer vacation with their kids, trying this case. And That coupled with the fact that the prosecution communicated to the court that they believe that their case would take 6 full weeks to present. That's not including jury selection and not including penalty phase and not including the defense's side of things. Ann Taylor said she believed that her defense would take at least 4 weeks. So now we've got 10 weeks of innocence guilt phase, excluding jury selection, any motion practice, any of those things. So we've got potential for 10 weeks of actual nuts and bolts trial where the jury would be seated. And then the prosecution said if there is a finding of guilt, they anticipate that their penalty phase would take a week. Ann Taylor said she believed her mitigation case would take 3 weeks. So now we're at 14 weeks of trial and penalty phase. So I think the judge is going to say, if we're going to do that, I am not going to keep these people through their whole summer. I'm going to start trial in October so that people can have their summer vacation. Kids are back in school, so we don't have to deal with childcare issues quite as much. And then that trial will go for 14 weeks. 14 weeks is a long, long trial. I mean, short of Young Thug, I don't know that anybody's seen a trial that long. So I expect that we're going to see that trial start in October. Ann Taylor still has a lot of motions to file. She told the judge she has motions opposing the death penalties, motions to suppress. We haven't heard any of those motions yet. None of those motions have been heard yet. It's going to be interesting to see what position that this judge is going to take on pretrial motions. Now, you'll recall that Judge Boyce did not allow any pretrial motions to be live streamed. We were able to get the recordings of them the same ways we did Lori's trial, but we weren't able to see in real time and have those motions live streamed. That may be something that this judge will have to do as well, because you don't want to flood your jury pool with information in motions to suppress, because if you suppress the information, you can't unring the bell. So that going forward could be possible that we're going to have more limited access, hopefully that's grammatical, more limitations on access to the pretrial motions. And there are going to be a lot of them. I mean, a death penalty case typically has a lot of pretrial motions. I don't think we saw nearly the number of pretrial motions in Vallow Daybell that I would have expected. There were some sort of pro forma kind of perfunctory motions on challenging the death penalty that every death penalty lawyer files, hoping that it's going to move ahead death penalty law in general. But I was surprised we didn't see more very specific motions. Ann Taylor is incredibly experienced, and she is also incredibly professional, and she comes to court impeccably prepared. So I don't anticipate that she's going to cut any corners in this case. There is another factor, and it is a factor that we're seeing in a couple of different Western states, including my home state of Oregon, which is still grappling with that. And that is that the way that public defense is being administered and the way that public defense is being provided is changing. So we had several of the Western states, and this is just wonky defense attorney stuff, so I'm going to try not to get too deeply into it. But the way that the states were providing was that they were contracting with private attorneys who were getting together in consortia to negotiate a contract with the state to provide public defense. The problem with that was that they were paying on a per case basis in a lot of states, or at very reduced hourly rates. What that meant was attorneys then had an incentive to take as many cases as possible to make more money, to make a living wage, because some of those were as low as $25 an hour. And what that meant was that they were being put into positions where their interests were in conflict with their clients. They weren't able to fully pursue the kinds of investigation and the kinds of defenses that they would normally, because they were carrying these horrendous caseloads and having to carry those horrendous caseloads in order to make a living wage. So Oregon is in the middle of the governor completely revamping how public defense is going to be provided. And like most states, and so is Idaho, and like most states, their contracting periods start in October. So Ann Taylor expressed to the judge that she was really unclear at this point what those contracts going forward were going to look like, because they were being taken out of the hands of the counties where they've always been and put into the hands of a state public defender. Ann Taylor, my understanding is that Ann Taylor has been tapped to potentially be the lead public defender statewide, which would be wonderful for the state of Idaho, but could cause some problems for her caseload. I suspect that she would continue to represent Brian Kohberger, and that she would wrap her cases up as time went on. But she expressed that concern to the judge. The judge said, I'm not as inclined to delay the case because of that, because I think that's all going to get ironed out over the summer, but it is a consideration. I think the two biggest considerations are the fact that this is going to be a minimum of a 14-week trial, and it would be unfair to jurors and difficult to seat jurors if they knew they had to give up their entire summers, especially people who have kids and whose time to vacation with their kids is summertime. So, and the other factor is that Ann Taylor's mitigation process is having to start all over again. So that being said, I think this judge is going to push forward. I think he is not going to put up with some of the nonsense that the prosecution has done in the past. And I think that he is going to expect that both attorneys, both the prosecution and the defense, are going to be professional, and they're going to move the case along as expeditiously as possible, while still guaranteeing that Brian Kohberger is going to get due process and fair trial. I will say, I've said before, and I will say again, it is very unusual and rare to have an attorney who is as wise and as experienced as Ann Taylor is. Yes, it's still allergy season. Fall is allergy season too. To have an attorney who is as proficient and wise and experienced as Ann Taylor categorically state that she believes that her client is innocent, that is a rarity. It is much more common for a defense attorney to say, I am going to absolutely uphold my responsibility to protect my clients' rights, protect their, assure they receive due process, assure that the process is fair, and let the jury make a determination as to guilt and innocence. That is a much more common thing that you hear from defense attorneys. It is very rare to hear a defense attorney say, I am absolutely convinced of my client's innocence. And particularly somebody as accomplished as Ann Taylor. So, okay, now I think we're ready to talk about, to take questions. I want to say I missed you guys, missed doing this. It was great to have a little time to play in Vegas, and it was wonderful to be in Portland and doing Pal's books, but I missed y'all. Shelley's Flowers. Does this activity by the judge in the Delphi case set this up for the approval by the appellate court? Yeah. It clearly sets up appeal. She has been so categorically biased against the defense in this case. I cannot imagine, and I'm not in the Midwest, but I definitely take the things that Bob and Ali Mata from Defense Diaries say to heart. They're in Illinois, and Bob has been following Delphi since the very beginning and travels to Indiana for the trials, and will be in the trial. And Judge Gull has ordered no live streaming and no recordings are to be produced. So the only way we're going to know what happens in court is going to be people live tweeting and people who are able to report directly from the courtroom. So it's great Bob's going to be there. He has said from the beginning that he believes that that she is biased, and if the appellate court doesn't recuse her, that basically this is a practice run, because there's no way that the appeals court isn't going to overturn her if Richard Allen is convicted. But we all know that appellate overturning cases and the appellate arguments are a much steeper climb. And so we all want to try and head off a conviction, because it's much more difficult to get a conviction overturned than it is to stop one from happening. But that doesn't seem to be possible at this juncture, thanks to Judge Gull. Now, there was some discussion about whether or not the attorneys were going to file an original action with the appellate court asking once again to recuse Judge Gull. I don't know whether that's been done, but clearly it is not going to happen before the trial starts in 2 weeks. So that means they're going to go to trial. They cannot make the third party culpability argument. And all of Richard Allen's somewhat disordered confessions are going to come in. So I think it's going to be ripe for an appeal. And I think it's going to be ripe for a new trial. Oh, Rhiannon says no live tweeting either, just reporting. Man, that sucks. Now that you say that, I remember that Bob was saying that he at the breaks, he would have to run out in the hall and tweet update. I think that kind of stinks. And I think that Judge Gull is doing it because she believes that that she's making questionable rulings, and that she is going to continue to make questionable rulings, and she would like to do that under the cover of courtroom privacy. So that's going to be a fascinating one to follow. And I'm going to be, like everybody else, I'm going to be relying on Bob and Ali to tell us what's going on. I know there are going to be other reporters there, but it is going to be handy to have a defense attorney in the courtroom who's able to decipher some of the stuff that's going on, because it isn't always clear when you if you're not familiar with that. For example, this morning's Sarah Boone hearing got started very, very late. We waited for a very long time for that hearing to start. My first response was, what are they doing in chambers? Are they talking settlement? Are they talking plea? I don't know. It didn't happen. And they came out and did the hearing, but there was a very long delay. That's something that having a defense attorney in the courtroom is going to know. So I will definitely be relying on Bob to tell us what's going on in the courtroom. And I'm sure that they will be doing as much live streaming as they can. Obviously, they can't do anything having to do with the trial, so they'll just be on being talking heads, I guess. So we'll see what they have planned for programming. So, Sam, will you be going in person to any upcoming trials? I don't know yet. Lori Vallow's trial has been in Arizona has been set out. There are a couple of trials that I'm really interested in. A lot of it's going to depend on what my next project is. So I'm really interested in the Adelson trial, and at one point thought about trying to attend that, but it was starting right in the middle of book launch, and that it just wasn't going to work. So depending on when it gets reset, I might try and do that. I'm also interested in the grandparents out of Kentucky or Oklahoma who murdered their grandchildren's mother. So those are a couple that I might be interested in. A lot of it is just going to depend on what my next project is. I am working on a book proposal. I am Dawn Shackelford. Thanks for asking. I am in the very early stages of a book proposal, another true crime book, and it will where I go from there will sort of depend on if that book proposal gets picked up. So I'll fill everybody in more as that develops. But I'm right now. I'm a lot of whether I attend trials is going to depend on, first of all, my schedule for doing book signings and appearances on the Vallow Daybell book, and second on what the next project is. So I am very much going to be working on setting up book signings. I'm like I say, I'm going to be in the Phoenix area in early February, and my publicist is working now on potential appearances there. And I am going to be in Boise at some point in the spring to do a signing there. So those are TBD, so watch this space. And please, if you have friends and family that are in southwestern Oregon, around the Ashland area, please let them know that I will be there Thursday evening on the 3rd for book signing. So May 2025 be your grandbaby year. Oh, your lips to God's ears, as they say. Thanks. My daughter and son-in-law are going to be. That could interfere, by the way, with our trip. We'll see. Could interfere with our Wednesday night, but we'll see. My daughter and son-in-law are going to be moving up in just about a week and a half, maybe 2 weeks. And so my husband and I are going to fly down to the LA area and help them drive back. My son-in-law has never driven a U-Haul truck before, so my husband's going to come back with him, and I'm going to drive cars back with my daughter. So we'll get everybody up here. They signed a lease on a cute little house in Bend, and we're just excited to have them close by. But it would not surprise me if grandkids were in the future, in the near future. So keeping my fingers crossed, because I want to be that grandma, that annoying grandma. How's the new house been treating you? Welcome back to Oregon. Hello from Portland. Hey, Sam, thanks for the welcome back. And the new house is a work in progress. Just some funny things going on. When the former owners, it's a lovely place. It's beautiful. The kitchen, family room area is to die for. And for any cook who loves loves hosting holidays, it's perfection. But the former owner went around, and you can kind of see a few places here. There are a few walls that are darker colors, and he went around and patched up all the nail holes with white spackle. So before I can really hang pictures, I need to deal with my polka dots. So, so that's on the agenda. And then our last two houses had built-in drawers, chests of drawers in the bedroom or in the master closet. So we didn't have any chests of drawers, but we have a big closet. So we decided rather than do built-ins in the closet again, that we would just get a couple of inexpensive chests of drawers. So while I was in Portland at Powell's, doing my Powell's thing, we stopped by IKEA and bought a couple of chests of drawers to fit in it, just for socks and underwear. And so my morning was trying to figure out how to put slot A and tab B together and start putting those things together. So tomorrow, before I head out in the afternoon for Ashland, I'll be working on finishing up that little project as well. But in general, the house has come together great. It's super comfortable. It is lovely to be back around good friends. My husband is thrilled to be back with his good friends, the guys he goes to Oregon State football games with. So I come back from Ashland, and he then bugs out for Corvallis to go to a game. So yeah, it feels great to be home. It's a beautiful time of the year to be in Central Oregon, and we're just enjoying it and looking forward to having our kids here. So thanks for asking. What other questions do y'all have for me? Hi, Mary. Did Judge Hippler rule on Brian Kohberger's clothes for his hearings? He likes his suits instead of jail scrubs. Yeah, he does. And, to be honest, this is a common request in any high profile case. The less time that you have potential jurors seeing your client in belly chains, leg shackles, and jail scrubs, the better from a defense standpoint. And we want him to get a fair trial. So what the judge said was he was allowing him to appear at the last hearing, and that he would make a decision going forward on that, but had not yet made a ruling. I expect that he is going to allow Kohberger to appear in street clothes. I think it's the fair thing to do. Now, I'm a defense attorney, but I think it's the fair thing to do. It's just like we don't want a jury to see our client come into court in jail scrubs and belly chains. We don't want potential jurors to see that either. Because if you have an opportunity to watch the hearing, the change of venue hearing, Ann Taylor put on some really interesting and important witnesses about the way that juries form opinions. And one of those experts talked about the fact that a lot of our impressions are almost at the subconscious level. So we could say, I haven't really heard anything about the case. I just remember seeing them bringing him into court in chains and jail scrubs. But subliminally, does that plant the idea that he's guilty because he's in custody? So if you have a chance to go back and watch those experts' testimony, I found their testimony really, really fascinating. I found it important as a way to understand juries and how juries perceive things. So if you like that kind of wonky stuff, I would say go back and listen to that change of venue hearing, because those those experts were all very accomplished and really good at testifying, and their descriptions of things and their explanations of things were important and well done. So yeah, I would recommend doing that. I think the judge is going to allow him to come in civilian clothes. Hi, Chelsea. It was so great to meet you at Powell's as well. I had such a good experience at Powell's. Not only did a couple of people I went to law school with 30 years ago show up, which was awesome. A couple of people who I had worked with were people who worked in child welfare in Bend and now have moved to Portland came, as well as some of my extended family. It was amazing. It was such a great way to kick off the book. The book came out on Tuesday, and I was at Powell's on Thursday, and it was amazing. And now we're off to the races. I was really excited to do that appearance segment on Channel 2, which is a Portland, big Portland ABC affiliate. And if you have any interest, that's in the show notes. And then I was thrilled to be able to be at Powell's, and thrilled to know that the book was being that excerpts of the book were being shown in the digital version of People magazine. So I think we're doing well at getting the word out that the book's out there. Please tell your friends if they are interested in true crime. If you have, once you have finished the book, please post a review. I don't expect that I'm going to get all 5-star reviews, although I love 5-star reviews. But I appreciate that you take the time, whatever the review is, to post one. And I want to thank everybody who read the book in advance and posted their review. And I also want to thank everybody who has reached out to me recently and given me some feedback about how they're enjoying the book, how the audio book is going. And that's important information for me too. I know that the book is not everybody's cup of tea. I know that there are people who are going to find my observations about the LDS Church grating, and I expect that. I expected at the time that I wrote the book that it was not going to fall soundly in the positive side of things for everybody. And I respect that, because I think we are a country who thrives on many opinions and on the First Amendment and being able to speak your mind and being able to speak truth to power, whether it's the LDS Church or our own government. So I appreciate everybody who has read and given me feedback already. And I hope that those of you who are just diving into it are enjoying it. I was excited when people started saying, oh, yay, it's coming. One woman said she was getting ready to leave on a cruise and she was excited to be able to take it with her on her cruise. So I hope that it is a combination of in-depth and readability. Sometimes when people get too far in the weeds, readability goes out the window. So I'm hoping we struck that balance. I struck that balance. So do we have other questions or are we ready to wrap up tonight? Thank you, Victoria. I appreciate so much my friendship with the women who I met when I was in Boise. And Victoria, I'm going to come through Boise on my way to McCall in early November. I hope that I might have a chance to see some friends then. But I am absolutely committed that we're going to do a book signing early next year, if possible, in Boise. And I want to see and have lunch and visit with all my Boise friends. So, and I talked over the top of your last post, Jen, so you might repost that one. My twin is LDS, and my my conversations and my book was an eye opener for someone who maybe has a family member who's a church member, but not a member themselves. Well, yeah, I mean, I think that it is important not only that people around members of the church know what church members believe, but I think that it's important for church members to maybe know that this more fundamentalist group is really embedded in their mainstream church. And I think they should be worried about that. It should be concerning that this very hyper-conservative, doomsday fundamentalist group is hidden like Russian nesting dolls in their church. And I think they should be concerned about that. Because Lori and Chad were not the only ones, not by a long shot. And that's what I tried to point out in the book. Lori and Chad were kind of the tip of the iceberg because there are a lot of other people who espouse the same beliefs and who could be every bit as dangerous if the church closes their eyes to it. So somebody says they found the book on Apple Books. That is probably true because the digital versions as well as the Audible versions are available on whatever platform you use. I sometimes download audiobooks on Apple Books as well as digital versions. So I think you'll find it on pretty much every platform. I don't know whether it is available in Rose K. This is a good question. I don't know whether it is available on Spotify yet. Rose K, this is an excellent question because CrimeCon is going to be in Denver in October of next year. So I have already made my hotel reservations, and I am hoping that I'm going to be. I'm hoping that I might get an invitation to be a speaker for CrimeCon. So that would put me in Denver in October of next year. So probably not as soon as you would like, but I wouldn't rule it out either. Denver's not that far away. So, and I've had invitations to Texas, as well as I have a sister in Texas. I have some friends in Texas who've said, "Come down here and do a book signing." So I'm still mulling over what that's going to look like. Travel's not inexpensive, and we're still in the very early days of book sales, so it's not like royalties are rolling in furiously yet. So we'll see. But I appreciate everybody's invitations, and I definitely will be looking at more opportunities. I definitely oh, it is on Spotify. Thanks for checking, Jen. And I definitely will also be, I certainly will be looking at some opportunities in Southern California, because I still have family there. We're going to be down there around the holidays, but that's certainly not a good time to do a book signing. So I'm hoping that springtime maybe we'll do some signings in the LA area. So stay tuned for more, because I'm going to try and do as many as I can. As I said, if you have a hard copy of the book and you would like a signed book plate, please email me and I will. Jen, you're so darn quick. I will send you a book plate. No charge, just thanks for buying the book. And I'll sign it and personalize it. So if you send me your mailing address in an email, you will get a book plate. And as a matter of fact, I have a whole stack of thank you notes and book plates that are ready to go out tomorrow morning, from folks who have posted their reviews and sent me their addresses. So please keep doing that, because I love dropping you a little note in the mail. Let's face it, we don't get that much snail mail anymore. So it's nice to get a piece of mail that isn't just an advertisement. Question: why couldn't Sarah Boone's defense just remove the makeup before returning her to jail? Well, that's a good question. I don't know. I don't know the logistics of that. They'd have to come up with, jail approved method of doing that, whether it's makeup remover, whether it's, I mean, I don't know. Um, I don't think it's insurmountable, but I also am not sure that um, it's really worth fighting about at this point. I mean, her trial is coming up, and she really, she needs to be focused on that and not on whether or not she got mascara in front of the jury. Sarah really needs to be, and her attorney need to be focused on how she is going to present herself to the jury, not whether she's wearing makeup and got her hair combed, but what her facial expressions are going to be and what her demeanor is going to be in front of the jury. That is way more important than her makeup. So I'm sure that if the court can accommodate it, they will. And because I just think it's the humane thing to do. But on the other side, I can see the the law enforcement perspective as well. So, I mean, they may come up with a way that they can wipe all the makeup off before she goes back to jail. So, we'll see. Oh, thank you. I'm not a big one to, put out all over on social media. It's my birthday. So, I'm, but thank you. My birthday was earlier this week, and I had a great birthday. My husband gave me a couple of nice gifts. I got a lovely new Dutch oven, enamel Dutch oven that I had wanted, so I can make big loaves of bread. And a couple of books. My daughter sent me something. We had a nice FaceTime visit over birthday dinner, and it was great. So thank you. The years just keep marching on, and it's not how many there are, but what we do with them. So if there are no other questions, I'm going to wrap up and say goodnight. So. Give Jen a chance to see whether or not we have any other questions. Please, 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 she says no. Please, please, please post your reviews. And thank you for everybody who already has. And thanks for all those who have bought the book. And I would love to correspond with you. So I'm going to say goodnight. I will see you next week when we'll be back again for True Crime Wednesday. Good night. Gotta push the right button.